KTN News, Nairobi.
Now, a three-judge bench will on Wednesday at 3:30 p.m. rule whether they will hear three cases challenging the impeachment of Rigathi Gachagua, of course, as deputy president, after an application was made by his lawyers on their empanelment, which was done by Deputy Chief Justice Philomena Mwilu. The petitioners are seeking their recusal, claiming they are biased against them. Our reporter Fred Kangonye reports.
The three-judge bench made up of Eric Ogolla, Anthony Mrima and Dr. Frida Mugambi today began hearing petitions challenging the impeachment of Rigathi Gachagua as deputy president. Gachagua was himself present in court as the case to decide his fate kicked off. As soon as the matter began, petitioners' lawyers led by Paul Moite, Kibe Mungai and Ndegwa Njiru argued that the impanelment of the bench by Deputy Chief Justice Philomena Mwilu was unconstitutional because the work of empaneling a bench is preserved for the Chief Justice Martha Koome alone.
Unless the Constitution is interpreted or amended to give the Chief Justice, the Deputy Chief Justice, the power to empanel a bench by express reading of the Constitution, she cannot be able to do that.
The bringing of that file in the middle of the night from Kerogoya, to presumably the Deputy Chief Justice, was another gross irregularity.
They argued that the three judges had already presided over another matter where Gachagua sought to stop the impeachment process, but they did not grant him the order sought and set Thursday as the hearing date of the case. The respondents, led by Attorney General Dorcas Oduor and former AG Professor Gethu Muigai, argued that the application by the petitioners was ill-timed and that Deputy Chief Justice Mwilu could impanel a bench in the absence of Koome, which was the case.
So when counsel repeats again and again, things were done at night. Well, a lie can go halfway around the world before truth wears its pants.
Chief Justice, who is the deputy head of the judiciary, by dint of Article 161, Subarticle 2B, can exercise the functions of the Chief Justice.
On the matter of Koome being outside the country, the petitioners argued that in her memo, she said that she could be reached via email or phone, which means she was in a position to constitute the bench.
Even assuming that in writing the Chief Justice had assigned this role to the deputy, and that has not been alleged, it would still not be good enough, because wherever that the good Chief Justice might be, this is something that she could have done as expected her.
The three judges will rule on this matter tomorrow at 3:30 p.m.
Legal arguments which were put, they are going to assist us to reach a decision which we shall render tomorrow at 3:30 p.m.
Fred Kangonye, KTN, Nairobi.
Well, of course, that will also make part of our conversation tonight with the key voices that will be joining me.